Professor Bruner, welcome to the Dare to Know podcast.
Thank you so much. I appreciate the invitation.
So in today's conversation, I would like to discuss with you a variety of topics you have extensively written about, namely issues concerning the nature of the corporation, the appropriate legal conceptualization of the corporate form, and our understanding of corporate law and corporate governance, especially as they relate to the aims of global sustainability. Perhaps, however, I could begin by asking you to make some introductory remarks about the significance of the corporation as a legal invention, the reality of the power of corporate entities in our current institutional landscape, and why it is that we should care about corporate entities, including corporate groups, if we hope to approach and answer questions having to do with sustainability.
Absolutely. So in my most recent monograph titled The Corporation as Technology, as the name implies, I characterize the corporate form as a type of social and legal technology, and I consider it an enormously powerful one for reasons that I think are acknowledged conventionally in the literature. I think there's no question that corporations have become among the very most important economic actors in the world, if not the most important category of economic actors in the world. And that is largely because of the capacity of their core attributes to unleash very, very powerful risk-taking on behalf of large pools of capital providers. As a consequence, the structure of the corporation is really critical to understanding why corporations are able to perform this sort of role. And there's no question that they do a tremendous amount of good. They provide goods and services that people need or at least want. They provide employment opportunities for much of the population in I would venture to guess, most economies around the world. And they provide investment opportunities for people who are saving for long-term goals, such as their retirement or the education of their children or what have you. So these are tremendously powerful and beneficial effects of the corporate form. At the same time, there has been growing concern over recent years and in fact decades that the corporate form may almost be too good at unleashing risk. That the corporate form is such a powerful incentivizer of risk taking for managers and the capital providers who are making the resources available to corporations that they sometimes run amok and effectively generate excessive amounts of risk and perhaps in certain respects the wrong types of risk. And as a consequence, I think we need to be devoting a lot of thought and attention to trying to recalibrate the corporate form so that we can capture the very significant upsides and benefits that they provide, while at the same time mitigating the costs. And most of the work that I have been doing in recent years is focused on trying to develop ways that we can better strike this balance. I think sometimes for people who are champions of the corporation, it's very easy to get swept up in the benefits without acknowledging the costs. And I think by the same token, it would be fair to say that for people who are critics of corporations, it's very easy to focus excessively on the costs without acknowledging the very real benefits and why this form has become so ubiquitous in the modern world. So again, the real point of most of the work that I've been doing is to try to find ways to better optimize, to strike these balances in a way that captures as much of the upside as we can have without exposing ourselves to unacceptable levels of cost, which again, as I said, I typically think of in terms of excessive risk and the wrong types of risk.
So I think there's a lot to unpack there. Just to get things started, if we take a step back and we ask about the nature of the corporation, one thing one could do is to actually look at corporate law. So then we ask the question, what is corporate law? Interestingly enough, you yourself mentioned that if you look at the literature, one cannot find much on this question of what is corporate law. And so in several of your articles, but also in your recent book, as you just mentioned, but let me mention it again, The Corporation as Technology, Recalibrating Corporate Governance for a Sustainable Future, you try to make some headway on this question, and you identify three particular approaches that one may adopt to address this question. So Maybe you could just briefly outline what are these distinct approaches in trying to specify the domain of corporate law and what are its strengths and weaknesses.
Yeah, so as you suggest, as a predicate to the analysis that I provide in the book, I tackle this question of how we should think about what the corporation is through the lens of the existing literature. And closely related to that question, as you suggested, this question of what corporate law amounts to. Necessarily, the two are going to have a lot to do with one another, because one could, as sort of a basic stab of the question, say, well, corporate law is the area of law that relates to corporations, which then makes the question what a corporation is. The two questions are ultimately distinct but closely related in that way. So as you suggest, in the existing literature, as I see it, you have a few different types of strategies that scholars and judges and policymakers and others have employed to try to understand what the corporation is essentially, and then related to that, what this domain of corporate law would embrace to some degree based on an account of what the corporation actually is in the first place. And the first of those is this approach of saying, well, corporate law is the law that relates to the relations among some core set of constituencies, some core set of actors who are in some sense relevant to the corporation and its operations. The problem with these types of approaches is they tend to rest on bald assertions about which groups are to be regarded as internal to the corporation and which should be regarded as external to the corporation or only dealing with it at arm's. And so, as I know you're aware, in English law, in American law, in lots of Anglo-Commonwealth jurisdictions, it is quite common to generalize that the internal corporate actors are essentially limited to boards of directors and shareholders as the fundamental sets of actors. They would typically acknowledge officers as possessing delegated authority from the board of directors, but fundamentally they'd be focusing on directors and shareholders. And then the corporate law would be defined as essentially the body of law that governs the relations among those core corporate actors. Now, the problem with this is it tends to simply rest on the assertion that these are the relevant internal corporate actors, whereas other groups of actors who we would sort of more generally think of as closely related to the operations of a business firm are just sort of defined as being external to it. So the most obvious would be the employees. And here we encounter an interesting inconsistency between legal theories of the corporation and economic accounts of the boundaries of the firm, because in Anglo-American law and in the law of Commonwealth jurisdictions, other jurisdictions that trace their legal origins to English judge-made law, the employees are typically simply defined as outsiders to the corporation who interact with it only through arm's length negotiated contracts, whereas in economic accounts of the boundaries of the firm, much has to do with the role of workers and managerial fiat relative to those workers. I'm thinking of the Cossian conception of the firm economically. And of course, there are other legal systems around the world, notably in Europe, but also elsewhere, that will define other sets of actors as having a sort of internal relevance to the operation of the firm. So here we might think of the role of employees in a continental co-determination system where employees have a direct role in corporate governance in a way that they generally don't in systems like the English system or the American system. So sort of stepping back from this sort of first approach to thinking about the nature of the corporation and the domain of corporate law, these accounts generally don't rest on any really fully developed explanation of why we should think of only boards and shareholders as being internal, while other constituencies like employees are conceptualized or simply defined as being external. So that's sort of a problem with these accounts in terms of helping us understand what a corporation is fundamentally about and what the domain of corporate law is. As I noted in the book, in many such instances, these observations are offered in sort of a preliminary introductory spirit to generalize about predominant preoccupations of the field, but without providing a really rigorous account of why those are the preoccupations of the field. So there are other approaches to how we think about the nature of the corporation and the domain of corporate law. Another is to focus on purportedly core features of the corporation. So here we might look to generalizations about what the elemental features of a corporation are and the sort of utility that they provide in terms of how corporations are managed and how they interact with markets and the world. So, for example, you will often see the corporation and by relation to that, the domain of corporate law defined by reference to purportedly fixed intrinsic attributes of the corporation, like a distinct legal entity, limited liability for shareholders, freely transferable shares, centralized management under a board that is elected by equity holders, the shareholders. There are multiple problems with this sort of approach, however, to understanding the nature of the entity and the domain of the law in this area. One is that lots of different authoritative discussions of the core attributes of the corporation are inconsistent with one another. So you'll encounter some that really emphasize the role of shareholders as an accountability mechanism vis-a-vis the board, others that place greater emphasis on a sort of wedge driven between passive shareholders in a publicly traded company and a much more autonomous managerial function, yet others that describe various aspects of the form that are particularly relevant to making potential creditors more comfortable lending money to the corporation. So this is gesturing toward concepts like asset partitioning that are really facilitated by a distinct form, but other aspects arguably of the corporation as well. So you run into this problem that there isn't really sort of a single authoritative account of what those purportedly fixed intrinsic attributes are that would help us understand what is a corporation and what is not, and by association, what would be within corporate law and what would not. And at the same time, those accounts don't really acknowledge the degree of flux and dynamism that there was in the emergence of the corporate form over a period of centuries. For example, limited liability for shareholders in retrospective accounts is often treated as close to the very essence of what a corporation is and how it works. But of course, doctrinally speaking, limited liability was a late arrival in terms of what we, or what are typically spoken of as these core corporate attributes really taking shape in the latter part of the 19th and the early 20th centuries, suggesting that you can have something that functions as a corporate form without it, as occurred for long periods of time. And of course, there's considerable variation across jurisdictions in terms of how these different purportedly fixed attributes actually function. So this type of account of what a corporation is about and how we know the domain of corporate law when we see it similarly runs into these sorts of problems. A difficulty sort of accounting for what is in fact the range of different approaches that coexist today and the dynamism and flux that occurred over long periods of time as modern corporations took shape. So a third approach that you'll often encounter in the literature focuses on theories of the corporation and sort of the consistency of the doctrine as we observe it with those theories. Here, of course, also we have a whole range of theories that have different levels of purchase in explaining different elements of the doctrine. So there are more shareholder-centric theories that are very good at explaining aspects of corporate law that do favor shareholders, but not so useful when we look at other elements of the field that don't favor shareholders. Related to that, we have other types of theories like team production, for example, that can go a long way in helping us understand very high degrees of board discretion in lots of different circumstances, including things like hostile takeovers, but also in the more general operations of the company, but that have a tough time explaining the elements of corporate law that really do tend to favor shareholders. And so these theoretical approaches also founder if the project is to try to come up with some singular theoretical explanation of the entirety of the doctrine, which isn't always internally consistent. And of course, as we were noting, can vary a lot from one jurisdiction to another. So all of these types of approaches that one encounters in the literature as it exists experience real difficulties in terms of providing a sort of singular, holistic explanation of what the corporation is and what the associated domain of corporate law is. And the argument that I develop in the book in response to this is that they're basically all to some degree failing to grapple with what the drivers of divergence are across different accounts of the corporation and different applications of this sort of structure in different jurisdictions and different places over time. The legal context can be a big driver in terms of sort of pushing the corporation to operate in one way in one jurisdiction and in a different way in another. Different market structures, different social attitudes about the role of business in social and economic life are all things that can lead the corporate form to be deployed in different ways. And as a consequence, my view, developed in the book, is that we need a different and better account of how the corporation actually functions elementally and how it is that it can be deployed in such different ways.
No, that's extremely helpful. Thanks for giving this overview of the landscape, I suppose. Now, another question I've been long wondering about is why it seems like the philosophy of law as a field has rather little to say about corporations and or corporate law. For example, if I look at the table of contents in the book, A Companion to Philosophy of Law and Legal Theory, several areas of law have their own chapter in this book, including property law, tort law, and criminal law, etc. But corporate law is not in there. And I was wondering, do you by any chance know why this is the case? And furthermore, do you think that philosophy of law could be a useful lens to look at some of the presuppositions of corporate law as it is currently conceived of?
Well, I think you're right that the corporation as such has tended not to attract a lot of attention as a subject in and of itself in the philosophy of law. It's not to say that it's attracted no attention, but I think it probably is a fair generalization that there's not a sort of robust, deep treatment of the corporation itself from the perspective of philosophy of law. Although I think it is telling that the corporation is often looked to as sort of a quintessential example of certain dynamics that do receive attention in the philosophy of law. So it's interesting that Hart, for example, from a positivist perspective, looks to the corporation as a kind of exemplar of a legal concept that doesn't have a concrete referent in the world, that is completely contingent on the rules that we construct in order for it to operate. And for Hart, this principally serves as a kind of example of the circularity that we sometimes see in legal definition. So for example, if we ask the question like, what is a corporation or where is a corporation, we can't answer that in any way that isn't ultimately rooted in the body of law that gives rise to the concept in the first place. And in that sense, any other mode of defining it that doesn't sort of expressly acknowledge that would just be logically circular. And I find it interesting that those approaching similar sorts of questions with different kinds of theoretical postures arrive at a very similar conclusion. And so in the book, I talk a little bit about Hart on the one hand versus Cohen, writing from more of a realist perspective and arriving at a very, very sort of similar conclusion. Cohen describes this as thingifying legal concepts. And of course, for the realist Cohen, more of is on how this sort of move can function as a way to, for example, allocate resources and power in a way that is purportedly rooted in something definitional, but in fact is just sort of being made up by whoever is constructing the rules that give rise to the concept of a corporation in the first place. And so I do think what you started with there was a fair generalization, that there's not a lot, and from my view, not enough of a focus on the corporation as a subject for really concerted study in that regard. But it is quite telling to me that it comes up as a very poignant example of fundamental dynamics of this sort in philosophical discussions of law.
So going along with the perspective that you'd sketch out, namely that there is no single, stable, comprehensive conception of corporate law, its domain, which is perhaps an approach that we may term a functionalism or functional approach in corporate law, which I think is one of the more dominant approaches. I thought it might still be useful for listeners to actually give an illustration of this sort of functional lens and the kind of commitments that these theorists sketch out for people that are perhaps less aware of these debates in corporate law. And in particular, I'm thinking about a quote that I would like to read from two prominent corporate law theorists, namely Henry Hansman and Rainier Krugman, I would like to read a quote from their article, which is titled "The End of History for Corporate Law," just to give a sense of the kind of claims that these scholars make. So I quote, "Much recent scholarship has emphasized institutional differences in corporate governance, capital markets, and law among European, American, and Japanese companies. Despite very real differences in the corporate systems, the deeper tendency is toward convergence, as it has been since the 19th century. The basic law of corporate governance, indeed, most of corporate law, has achieved a high degree of uniformity across developed market jurisdictions, and continuing convergence towards a single standard model is likely. The core legal features of the corporate form were already well established in advanced jurisdictions 100 years ago at the turn of the 20th century. Although there remained considerable room for variation in governance practices and in defined structures of corporate law throughout the 20th century, the pressures for further convergence are now rapidly growing. Chief among these pressures is the recent dominance of a shareholder-centered ideology of corporate law among business, government, and legal elites in key commercial jurisdictions. There is no longer any serious competitor to the view that corporate law should principally strive to increase long-term shareholder value. This emergent consensus has already profoundly affected corporate governance practices throughout the world. It is only a matter of time before its influence is felt in the reform of corporate law as well." So I would like to maybe just briefly bring this in and see, of course, you sketch a very completely different picture, but I thought it might still be useful for listeners that are unaware of this debate to hear the tone of, let's say, the functional approach. So maybe you have a brief comment, like you could maybe sketch some more context about, this title of this article even. What are we to make of it?
Yeah, so I think it's a useful counterpoint to identify relative to my approach, because as you suggest, it very decidedly reflects a functionalist approach to comparative corporate law and governance. And to clarify what we mean by that from a methodological perspective, functionalism essentially starts with an assumption that different jurisdictions are more or less trying to solve the same kind of problem, and then sort of focuses the comparative undertaking on looking at similarities and differences and how different jurisdictions approach solving that problem. And as your identification of this particular example really reflects, it's often bound up with a kind of further assumption that it would be possible to identify among the different choices that jurisdictions make a sort of optimal approach that we could expect to be identified as such, and upon which different jurisdictions would converge at varying rates of speed over time. The idea is that everybody's trying to solve the same problem. Basically, they're going about it in different ways, and stands to reason that eventually, looking at what all the different jurisdictions did, we would identify sort of the best way, the most efficient way, the optimal way to go about it, and that there would be convergence on that sort of approach. And in fairness to the authors, I think it should be noted that that article was written at a time where it really did look like a lot of capital market related practices around the world were strongly converging on a shareholder focused paradigm that looks a lot like what you would see with publicly traded companies in the United States and the UK, maybe to a lesser degree. Now, fast forwarding to the present day, yeah, I think we have seen some convergence of that sort, but we have seen very persistent divergences in corporate governance structures at the same time. And we have also seen that even in circumstances where it appears that there is convergence, that just beneath the surface are lurking very substantial differences in the way those nominally identical structures are actually operating on the ground, because they're working in very different contexts. And at this point, relative to that background that we've just given in response to the Hansman and Crackman article, I can maybe say a little bit about what I see as the principal alternative methodological posture and kind of where I fall in terms of the way that I tend to approach these things. Relative to functionalism, contextualism is a very different approach that really emphasizes differences first, in the sense that they are sort of in the foreground, and sort of acknowledging and grappling with those divergences is really the principal aim of the comparative exercise. Now, having just framed it that way, it will already be apparent that this involves relaxing the assumption that different jurisdictions are necessarily pursuing the same goals through what appear to be cognate types of law. And also, I think it's fair to say, largely abandons the assumption that there would necessarily be some identification over time of a single best, most efficient, optimal way of doing things. So in other words, it's much more alive to the possibility that substantial divergences really could persist over time, and the project becomes sort of understanding those divergences in as nuanced and useful a way as one can. Now, in reality, I think if you try to adopt a very pure version of either of those methodological approaches, it becomes difficult to make much headway. Real sort of true functionalist approaches often find it very difficult to grapple with persistent divergences over time, or the sorts of variables that might result in a nominally similar type of legal structure being deployed in different ways in different jurisdictions. That's the sort of question, the sort of challenge that the methodology isn't really hardwired to be attuned to, and consequently, theorists who adopt very strong form versions of that sort of methodology often find it difficult to grapple with those types of dynamics. But it has to be said at the same time that a pure form of contextualism could itself be very difficult to deploy, because it's susceptible to the criticism that it's not rooted in anything. Like, if everything is just difference, then what would the basis for a comparison be in the first place? And so, personally, I tend to, I suppose, come down in the middle in a couple of methodological respects, while probably leaning more in the direction of contextualism in terms of how I see things playing out over time. So the senses in which I sort of fall in the middle would be to say that I am open to the core functionalist assumption as a kind of working hypothesis. Like, we could start with a basic assumption that these types of structures are being directed at similar types of problems, and undoubtedly at a mid-level of abstraction that is true. I started out with a description of some of the benefits that we hope to get through corporate production, and those sorts of benefits would be generalizable across a very wide range of cultures and market contexts around the world. So in that respect, from a functionalist perspective, so far so good. By the same token, I think that we have to adopt a posture where we are open to the possibility of kind of iteratively revising the working hypothesis as we encounter more difference in the world, and being open to the possibility both that the fundamental goals might not be identical in all jurisdictions, and that nominally similar structures could be deployed in very different ways. So for example, with the corporation, different jurisdictions could approach problems related to employment, related to investment opportunities, and so forth in very different ways. In prior work, I've suggested that the way in which corporations are involved in the pursuit of social welfare goals varies enormously, even among jurisdictions that one would imagine were very, very similar from legal and market perspectives. So, for example, just comparing the United States with the likes of the UK, Canada, and Australia, we find that the publicly traded corporation has a very different role in the provision of social welfare in the United States because of the centrality of the employment relationship in things like retirement savings and healthcare and so forth. A lot of those things tend to be very, very bound up with employment status. So that puts the corporation in the United States in a position of doing a different type of social welfare related work than a similar structure would be doing in another jurisdiction. And so, the world being very complicated, I think we have to try to acknowledge both some degree of commonality in the types of problems that we're trying to solve through these sorts of structures, while at the same time acknowledging that there could be real non-trivial differences in the work that these structures are doing. And to the extent that they're doing different work, that means that there are going to be all sorts of different legal and social and economic forces that sort of push the entity and the related doctrine in one direction or another. I know this was a very long-winded answer to your question, but basically, I think this is the sort of complexity that we have to grapple with that requires, to some degree, drawing both from functionalist and from contextualist impulses if we really want to be able to get anywhere and produce anything fruitful through this type of comparative study.
Right. And so when we look maybe a bit more at these kind of contextualist drivers, so you already gave one example just now, but one that actually stood out to me that I thought was also very interesting, namely on the historical dimension. So when we look at historical differences, at one point you introduce or highlight the importance of the public-private distinction in the context of different conceptions of US corporate law's scope and content over time. And in particular, at one point you mention, and I cite, there is no clear public-private distinction between the state and business. In some instances, states and other public bodies are directly involved in business, notably as controlling shareholders and as institutional investors. Conversely, there are prominent cases of strong corporate influence and outright corporate capture of legislation and of regulatory enforcement. This implies that corporate law and corporate governance must also engage with perceived political issues of inequality and living wages, with the implementation of international human rights, and with the regeneration and preservation of the ecosystems on which we depend. And so, one article that also came to mind for me was an article titled Beyond Public and Private, Toward a Political Theory of the Corporation by the political theorist David Kipley. And he goes so far as to suggest, and I quote again, that corporations need to be placed in a distinct category, neither public nor private, but corporate, to be regulated by distinct rules and norms, because corporations cannot be well placed into the public-private distinction that constitutes liberal political thought. At one point, he goes so far as to state, the point I am making, however, is not just that the activities of corporations transgress this divide, but that their very being transgresses this divide. So I'm wondering if you could maybe just highlight, this distinction, which is also central to like liberal thought, but also in political philosophy, it plays a massive role. So I'm just curious how this sort of is interwoven with this history of conceptions of the corporation and corporate law.
Yeah, so I think that is a potentially very fruitful way to think about where the corporation sits relative to this sort of conventional way of framing things as between public and private domains and public and private law. Certainly from that perspective, you could think of it as a sort of third thing, a sort of third domain, or perhaps as a kind of overlap in Venn diagram terms. That might be a way that I prefer to think of it, because of course, whether you're talking about individuals, corporations, or the public sphere, you're just talking about different combinations of people, by which I mean carbon-based breathing people, as opposed to corporate entities in and of themselves. The corporation is, on the one hand, a collectivizing structure that is aimed at marshaling the efforts of lots of people and directing them towards some sort of hopefully productive activity. And in that sense, there's a kind of commonality with governments, and particularly when you think about governance as such, as kind of a representative enterprise where people to some degree elect representatives and they sort of carry out a mission on their behalf. There is a kind of resonance between corporations and elected governments in that sense. But by the same token, they have a distinctly private resonance, much more akin to individual people, in the sense that we think of them as entities navigating markets that, at least to some degree, are not to be governed minutely by some sort of centralized dictate. So in other words, they go out and transact in the world in just the way that you or I could. So I think in that sense that I would probably prefer to think of them kind of in Venn diagram terms as a kind of overlap area between public and private. And I think also this conception, I think, also helps us sort of think through where different types of corporations would fit, because they wouldn't all necessarily have the same degree of public versus private resonance in that respect. So you've certainly got some types of businesses that look and act like an arm of the state, most dramatically where you have what is in essence a privatized version of what used to be a public ministry, performing something that looks like a very public function, like something elemental to transportation or something else that has a kind of infrastructural sort of feel and utility to it. By the same token, you can have businesses that look very, very different from that, and really seem to sort of have a stronger private resonance than that. So I think this is all relevant to the way that we think about the role of corporations and their regulation, because of course the closer they are to the sort of public conception, the more people would intuitively imagine that they would be subject to direct regulation and sort of a centralized hand in their governance. Another aspect of this, which I think gets to the historical dimension of this that you were pointing to, comes back to theories that have held sway at different periods of time in terms of how we think about what these entities are. And so there are periods of time where the prevailing conception was very much that a corporation was sort of this aggregation of individual people, much more akin, sort of closer to the legal definition of a partnership, which makes it feel like sort of a very natural extension of something that is completely rooted in the private realm. Of course, there are other periods of time where we've more strongly emphasized the fact that they only exist by virtue of a publicly granted charter. In that sense, they have a very decidedly public valence to them. So that's another aspect of this. What sort of theories hold sway at any given period of time? And of course, there's been a lot of flux over time in that regard.
Right. I have one question on that issue as well. So traditionally, I suppose there are these three sort of big theories of the corporation. So as you just mentioned, the aggregate sort of conception, where it's just, individual private members sort of interacting with one another. Then there's the concession theory that highlights maybe the role of government in making possible corporations as legal entities. And then there is the real entity theory, where there's something extra legal that has to be recognized. There's some autonomy that has to be given to corporate entities. And I'm just curious, because I think slowly we will be also moving to issues of sustainability, whether you think that those three big theories, if they can help us in this quest of trying to make sense how corporations could become more sustainable, or whether it is actually a divergence. So for example, John Dewey, the philosopher John Dewey, has this article in 1926, The Historic Background of Corporate Legal Personality, where he might be summarized as saying that there is a certain legal indeterminacy that all these, larger, somewhat abstract theories run into. And so that it is much better to maybe look at the context and the consequences that corporate entities actually generate. And that might fit, or seem to fit, with your story about also recognizing the contextual drivers and taking this kind of comparative lens. And that would be perhaps in contrast with other theories. So one person that I'm aware of is the theorist Susan Watson. So she has an article where she also raises the question, can the modern corporation operate sustainably? And she does seem to invoke, perhaps more than you do in your book, these kind of larger theories of the corporation. And there's many more theorists who might say, oh, we need to, just recognize this real entity in theory, maybe work it out slightly better. And, we have a better sort of angle to get at these kind of sustainability issues. And I know this is a very big question, but I'm just curious whether, how you situate yourself in relation to these sets of questions with regards to sort of these larger theories of the corporation.
Sure. Well, one aspect that you could think of as an implication of, or perhaps a soft version of real entity theory is this notion that we have to take seriously that there is something different about the sort of situation and form of organization where people are interacting in this way. So in other words, in its behavior, a corporation looks very different from a simple aggregation of all of those individuals who are supplying different kinds of inputs, because part of the corporate form is really aimed at, in a sense, leading people to contribute to something that is different from what would happen if they were all just behaving as individuals in that space. It happens in a few different ways. Think about limited liability, for example, and why this figures so centrally in conceptions of the corporation. Part of what it is undoubtedly there to do, I mean, arguably that the main purpose is simply to make people very comfortable with risk-taking. And to the extent that's happening through a centralized decision-making structure, it's decision-making from which the suppliers of capital who are kind of enabling it can then back away from, maybe not feel like they're directly bound up in it. In other words, there's a kind of psychological buffer between any individual person as an investor and the consequences of what their money is doing, precisely because the structure facilitates them handing over their money and then kind of checking out. And letting managers run with it. And the managers then are not necessarily going to behave in the way that they would if they were just sort of unconstrained moral actors, because they have these duties imposed on them by law, for example, to favor to some substantial extent simply generating a financial return. And so this notion that the entity fosters conduct that is collectively very different from what the sum of the parts would be if everybody were just sort of behaving as a kind of independent moral agent is something that I think is quite significant and has real purchase. Now, here we also come to the contextual point that you noted, which is that this can operate very, very differently from one jurisdiction to another, from one market within a jurisdiction to another market within that jurisdiction, from one industry to another, and so forth. And so I think coming back to sort of the contextualist impulse, this ought to encourage real caution about pushing too far the idea that we could come up with a sort of singular, fixed, real entity conception that was going to explain how this functions in all places and all times. I think we inevitably come back to a lot of the contextual features that I was suggesting earlier, which was part of what led me down this road of trying to come up with a much more flexible conception of what the corporation is and how it operates that could actually accommodate all of this and help us think creatively about how it's deployed in different places.
Right. So a few times throughout this conversation, we have perhaps already dropped the word corporate governance. So not only corporate law, but also corporate law and corporate governance. So perhaps you could maybe just briefly say, how does this transition work? How do they relate to one another? That may be helpful.
Yeah. And so corporate law, we're talking about what people will conventionally think of as a distinct area of law within a domestic legal system. But for reasons that we've already touched on in various ways, it becomes very difficult to draw apples to apples comparisons between corporate law in one country and corporate law in another, because they may well not be defined in the same way, because the corporate entity may not be defined in the same way. And so oftentimes what I have seen in the literature is retreat to the sort of broader umbrella term of corporate governance as a way of kind of bracketing these doctrinal distinctions between different countries and enabling comparison that is trans-doctrinal in the sense that it de-emphasizes a kind of taxonomic focus on what corporate law as such includes and kind of steps back to a sort of broader systemic view that is simply asking in a more generalized way, how are companies actually governed in a given place? And so you can see corporate governance defined in different comparative studies along these lines, but in different ways, depending on what the author wants to emphasize and the jurisdictions that the author is focusing on. So, for example, if one is comparing, say, the US and or the UK with systems in continental Europe that have co-determination type structures involved, we need a way to compare bodies of law that do not treat employees as part of the corporate law equation or as part of or as internal to the corporation with other systems that in varying respects do. And the corporate governance framing, let's say, provides a convenient, more overarching sort of term that would allow one to say, okay, what we're comparing here is the system that might embrace elements of corporate law, elements of securities regulation, elements of labor and employment law, elements of the social welfare state, and so forth. And we're sort of lumping all that within this broader concept of types of law that directly impact the way that companies are governed. That is how I have tended to think of corporate governance as a concept and why I think it became really significant. It's most significant in the context of comparisons that are difficult doctrinally because of the kinds of divergences that we were talking about earlier.
And so when we take this lens that sort of brings corporate law and corporate governance together, we can maybe now move to some of the main controversies or enduring controversies within this domain. And those are three core issues: the issue of power, so who ought to have the last word in corporate decision-making; the issue of purpose, whose interest and what values ought to guide corporate decision-making; and the issue of risk that you have several times referred to during this conversation, namely how much risk-taking is actually desirable, either in general or for a particular business context. So maybe can you situate those kind of three issues that have been at the center of some of the controversies in corporate law and corporate governance, and maybe give some more meat to them?
Yeah, so I think of these as three most significant examples of persistent divergence across the world today, but also very live issues within jurisdictions where the literature might lead one to believe that there was some kind of settled answer. So with respect to the question of power, as you just suggested, what we're fundamentally talking about here is who ought to have the last word within the corporation, who enjoys governance supremacy at the end of the day, we could say. And typically this is going to take the form of a preference for shareholders over boards or for boards over shareholders. Although, again, along the lines we were noting earlier, there are very different ways of thinking about how corporate power ought to be allocated. In the United States, we've had a very dynamic set of circumstances, I think essentially since about the 90s, when institutions became very prominent in the U.S. That's really when you started to see a rise in governance-related activism from big institutional shareholders that had enough of a stake in big public companies for it to be rational for them to get involved, and also brought the institutional sophistication to do so in a meaningful way. And a lot of what we have seen in the form of shareholder activism in the United States is basically a push for more power to be sort of devolved from boards of directors to shareholders themselves. And there are lots of different fronts in this larger battle. One of the more interesting ones relates to bylaw authority, which just that sounds like a very dry subject. But in a typical U.S. publicly traded company, you can have a situation where the shareholders and boards of directors have concurrent bylaw authority, which might in theory lead to a situation where shareholders could enact a bylaw for the company on Tuesday, and then the board of directors could scrap it on Wednesday. And in this sort of situation, we have to really dig into questions like, what is the core power structure here? What are the sorts of questions where shareholders should have the final word, as it were? And what are the circumstances where, no, we're going to favor boards of directors over what sort of narrow shareholder interest might be in any given sort of situation? So even in the United States, this sort of question is very much up for grabs, very dynamic, something that continues to evolve over time in terms of what the actual functional division of power is between shareholders and boards. And then along the lines that we were noting, in a system that has co-determination or some form of formalized involvement of labor, there is power that goes along with that. Fundamentally, a co-determination system has made the choice not to allow shareholder elected boards to monopolize power and to devolve some of that power to employees. And of course, that sort of structure goes hand in hand with shop floor level works councils and so forth, which will have decision-making power over various types of domains of activity. So these are all reflections of this larger dynamism that continues today, both within any given jurisdiction and across jurisdictions. Along the lines I was suggesting earlier, you can compare systems that we would imagine would be very, very similar in legal and market terms, like the US and the UK, and find very, very different balances of power. Shareholders, simply put, have a lot more raw governance power in the UK system than they do in the US system. And this is among systems that lots of people in the comparative literature would lump together as being sort of a single identical Anglo-American system. It's just not the reality. And then you see similar divergences across Canada and Australia, which you might imagine would be very similar to the US and the UK in these respects. All four of them have struck different balances in terms of how power should be divvied up, and all of them remain dynamic today. The next big question is the question of purpose. So this is related to, though distinct from, the question of power. Here, the question is, with boards of directors, what should be the sort of guiding star as they're making decisions? What should be the ultimate objective that they're trying to pursue? Should it be very narrowly focused on generating financial returns for shareholders over some specified time horizon? Or should it be some more holistic conception of the best interests of the entity as a whole? And this similarly is an area where we see flux within given jurisdictions that are typically treated in the literature as having some sort of settled answer. In reality, they don't, and where there are big divergences across different jurisdictions. So in the United States, this is a live issue in terms of how we ought to think about the orientation of boards of directors. And, as recently as the last few years, prominent organizations like the Business Roundtable making what many would consider surprising statements in sort of leaning in the direction of stakeholderism, and then, heated responses to that in terms of what the implications might be for accountability and so forth. But if there were truly a settled answer to this wouldn't even be a conversation. It remains a very sort of live issue, and there's a lot of hard thinking going on about what the appropriate time frame is for pursuit of those goals, whatever the settled goals might be. And then, of course, divergences again across jurisdictions in terms of whether they tend to think of it solely by reference to shareholders or by reference to some more holistic conception of the corporations or companies' interests. Now, in addition to that, I address as a core question this question of risk. How much risk do we want, and what sorts of risks do we want? And this is an issue that really came to the fore again following the global financial crisis in 08 and 09. Basically, what we had over a period of decades was a dismantling of the sort of regulatory structures that had constrained risk-taking in financial firms in particular, and in the United States, certainly arriving at a circumstance where big bank holding companies were more or less viewed through a governance lens, just like any other publicly traded company. Correlatively, we got a lot more risk building up on financial firm balance sheets. And in response to this, there were, I think, very logical questions raised about, should we be stepping back and rethinking what we want the risk-taking incentives to look like, both in terms of how the corporate entity is structured and in terms of what other sorts of elements of corporate governance and corporate form might be relevant to containing and channeling risk-taking. And although there have not really been substantial changes following the financial crisis in that respect, unfortunately, in my view, it's a very live question. And of course, there are other areas of law that affect risk-taking within companies, and much of the discussion of sustainability can be viewed through a risk lens, not all of it. I think it's a mistake to kind of reframe all of sustainability in risk terms, which is what you typically see in capital markets through the ESG lens. But a lot of these considerations that we think of as implicating environmental or social or economic sustainability are susceptible to analysis through a risk lens. And a lot of those are live questions in connection with greater attention to sustainability-related concerns over recent years.
Right. So I have a few clarificatory questions. So maybe to begin with the issue of power, I wonder to what extent should we sort of recognize the difference between, let's say, power in theory and power in practice. So I recall reading the book by, I think, legal theorist named Lynn Stout on the shareholder maximization myth or something along those lines. And if I recall correctly, in this book also the issue of, let's say, the business judgment rule comes up, where it is kind of suggested at least that this gives a lot of leeway for the board sort of to take power, I suppose. And I just wonder, like, does that speak to this distinction between, in theory, this is how we theoretically divide, who is supposed to have sort of ultimate power in the corporate structure versus in practice, how should this operate? Or is this issue about the business judgment rule not directly relevant to the question of power?
Well, so I think it's an initial matter that it's undoubtedly right that what we should care about in the end is actual power in the conduct of companies as opposed to mere theoretical power. So, for example, for a long time with highly dispersed shareholders in U.S. public companies, shareholders had theoretical power if there was some way to coordinate, but it was very difficult as a practical matter for shareholders to coordinate because their holdings were so fragmented. So just taking that example, what actually matters is real practical power, not mere theoretical power. And in thinking about what we want the balance of power to look like, it's not enough to just focus on the law on the books, as it were. We also have to think about how it actually operates. And if it isn't delivering the kinds of collective involvement that we have reason to favor, then we should be scrutinizing why and thinking about what sorts of responses could be made to that. So with the business judgment rule, I think that the business judgment rule maybe has certain relevance to the question of power insofar as it tends to insulate boards from accountability for the substantive dimensions of their decisions. So for example, in Delaware, what the business judgment rule essentially amounts to is a strong reluctance, if not refusal, of courts to second guess the substantive wisdom of business decisions when the board decision making was not impaired by some kind of conflict of interest, and when there's no reason to call into question the board's good faith. So in that respect, it is insulating board power insofar as it is taking off the table what might otherwise have been an avenue for shareholders to challenge business decisions that they didn't like. Of course, shareholders do possess other mechanisms that they could pursue to address board decision making that they don't like, notably by trying to remove directors. And so, coming back to the sort of activist landscape that I was describing earlier, one of the things we've seen over the last 20, 30 years is institutions pushing harder for both, kind of corporate electoral reforms that would require a higher level of endorsement before somebody could be on the board, in the form of, say, a majority election requirement, a majority voting requirement for someone to be elected to the board, and then facilitating removal of directors, say, by eliminating staggered boards that would tend to insulate people for longer periods of time on the board of directors. And so there's that kind of mechanism. One of the ways in which I think the business judgment rule is most relevant actually relates to the risk point, because you can really think of the business judgment rule as a sort of management level corollary of limited liability for shareholders. So limited liability for shareholders leads them to want more risk. And the principal justification for the business judgment rule is that it frees up boards to be comfortable to take the risks that risk-preferring shareholders with limited liability really want. And so the main way in which I think about the relevance of the business judgment rule is not so much in its relation to the power question, although I acknowledge that point that you make. I tend to think of it as functioning most significantly on the risk side, because if, for example, we wanted to curb risk-taking in a company, a logical way to do it might be to, at least in some kind of calibrated way, relax limited liability protection for shareholders, and at the same time think about relaxing some of those protections through the business judgment rule for the board of directors. Both of those things were historically done in banks with the specific aim of curbing risk-taking. And there's no reason that we couldn't be thinking about those sorts of things today. That's mainly the way in which I think about the relevance of the business judgment rule.
No, that's very helpful. No, I didn't see that connection with risk and how it can mirror sort of the dynamics of limited liability of shareholders. No, that's very interesting. So maybe one clarificatory question I also have, or maybe more of an open question, I suppose, is on the issue of purpose. So there has, of course, been a lot of debate about corporate purpose, both in practice, as you mentioned, at the roundtable, but also in academia. So in particular, I'm thinking about people like Colin Mayer. And there has also been, at least it seems to me, some optimism about what perhaps corporate purpose can do if embedded correctly in the domain of corporate law. And so maybe I would just like to read a brief quote by Colin Mayer, and then I'm curious like how you look at this, given that you recognize it is really one of the core issues in corporate law and corporate governance, whether this solves the issue, as is sometimes perhaps suggested. So I quote, and this comes from the article, "The Future of the Corporation and the Economics of Purpose" by Colin Mayer. So I quote, "How can business be reformed to internalize its externalities and align the future of the corporation with its purpose to provide profitable solutions to the problems of people and planet, and not profit from producing problems for either? The answer is remarkably straightforward. Since the corporation is a product of the law can define the nature of the corporation. There is no law of nature that states that the corporation must be as it is." And then he continues later on, "Company law should require firms to specify and implement whatever purposes they deem appropriate, provided that the second part of the purpose statement, namely not profiting from producing problems, is respected. Then any purpose is beneficial, even if it emphasizes profits over other considerations." And I'm just curious, what do you think of this sort of proposal that, purpose can do a lot of work for us and we should double down on it if you, let's say, subscribe to these kinds of views? So I'm just curious, what do you think?
Sure. So I think there are a few things going on there that we need to unpack and sort of treat distinctly. So the first is that existing corporate law gives companies a lot of discretion to specify particular purposes in their organic documents and to be guided by those purposes in their governance. And when I say that, I'm not just talking about social enterprise, although that would be sort of a crystallization of this kind of approach, where the law in some sense facilitates companies specifying some purpose that substitutes for pure profit maximization, or perhaps is to be balanced with it in some way, to specify that in the organic documents, and then to create structures that essentially insulate boards of directors from liability exposure for the fact of pursuing that kind of balancing. There is that. And there's, I think, a pretty strong argument that there was already a lot of freedom to do that through the tailoring of standard corporate charters, certainly in U.S. law before the advent of social enterprise. And so that sort of flexibility is there. And here we can also come back to the impact of structures like the business judgment rule and heavy reliance on managerial discretion about the timeframes for pursuit of corporate goals and what the strategy ought to be and so forth. There's, in that respect, a lot of latitude under existing law for boards of directors to bring, let's say, stakeholder interests and other types of values to bear upon decision-making if they want to, certainly as a component of thinking about what would redound to the long-term interests of shareholders. And the reliance on boards of directors, again, to set the time frame for pursuit of corporate goals and to define what those corporate goals are, goes a long, long way toward creating flexibility for boards of directors to do this. All of which is to say, I think existing corporate law gives enormous discretion to boards of directors to do the sorts of stuff already that Mayer is talking about in the excerpt that you read. Perhaps there are other sorts of things that we could do, and I think he's suggesting as much, to try to sort of nudge corporations further in that direction. But fundamentally, a lot of this discretion already exists.
Right.
So the question then becomes, given that this discretion already exists, has it proven to be enough? Now, here we're essentially asking for a kind of like empirical analysis relative to some preferred normative baseline. So for me, the baseline is sustainability. And I would look at this empirically and say, no, this has not delivered the goods. The mere fact that boards have this kind of discretion has not added up to the kind of sustainable corporate conduct that I ultimately would like to see, and that others who are proponents of sustainability as a normative goal would like to see. And from this perspective, I think it leads to a broader critique of what the different types of things are that affect the way managers exercise the discretion that they have. It's going to be things like capital market realities, expectations of investors, what the pressures are to generate returns over very short time frames, things like the regulation of pension fund managers and the duties and obligations of asset managers of various sorts. Now, to circle back to Mayer, everything I'm suggesting I think expresses a certain sympathy with his perspective, and yes, I am willing to acknowledge that there's something to it. But do I think that it's enough and that it's going to solve these problems on sort of in isolation? No, I don't. Because again, this kind of discretion has existed for a substantial period of time, and given the sorts of factors that affect the way that boards actually exercise that discretion, it has not translated into the kind of sustainable corporate conduct that I and others would like to see.
Right. So maybe at this point, it might make sense to actually move to the key positive proposal that you make in the book. So we have now, throughout the conversation, criticized along the way this kind of fixed conception with its fixed attributes of the corporate form. And now you make this new proposal, which is very exciting, namely the corporation as a set of flexible capacities that we can sort of conceptualize or visualize even as governance levers. And so I will also pop up sort of the figure that you have, on the screen so people can sort of see it. The dashboard is there. And now I'm just curious if you could maybe perhaps give a bit of an outline of this dashboard, how we should think about it, and how it sort of gives us explanatory power of making sense of the corporate form.
Sure. So the core idea here is to shift from an approach to conceptualizing the corporation that is rooted in the kind of effort I was noting earlier to identify fixed intrinsic attributes of the corporation by which we can know it when we see it. So things like fully limited liability for shareholders, centralized management in the hands of a board of directors elected by shareholders, and so forth. And rather to think about a series of flexible capacities that that invite choices that add up to the way that a given company is actually going to be governed. And so rather than thinking about a singular conception of strong form governance centralization in the hands of a board of directors, I tend to think more in terms of the flexible attribute of governance centralization that could be more or less centralized depending on the circumstances. So it could be more centralized in the hands of a board of directors, or it could be more dispersed in the hands of shareholders or some other constituency that is given some degree of decision-making power. So the idea is to recharacterize what others might tend to view as a fixed conception by reference to some current example that looms large for them, and to urge people to think about it as a sort of spectrum of governance centralization, that it can be more or less centralized. By the same token, a board's liability exposure could be increased or decreased relative to whatever the current baseline is. And this, as we were noting earlier, relates intrinsically to the question of risk. If directors have more exposure for the consequences of their decisions, that is going to leave them less comfortable with risk. Conversely, if they have less exposure, that's going to leave them more comfortable with risk. And so again, we have a spectrum here that we can think about in terms of how we want to calibrate that, either writ large for the corporate legal system or maybe in some particular industry context. Shareholder representation is another. So composition of the board of directors could be determined solely by shareholders, which is what we see in the United States, or other stakeholders could be granted some degree of representation. And so again, continental codetermination would be a quintessential example of a system that is essentially carving back some of the power from shareholders relative to a US baseline and allocating some of that power to employees. Shareholder orientation is another such lever that is amenable to being thought of as a kind of spectrum. And here we're talking about what boards are duty-bound to prioritize when they're making their decisions. We could require that they just focus like a laser on the interests of shareholders perhaps over some specified time horizon, or we could give them some degree of discretion to balance that against other interests, perhaps define it by reference to the corporate entity as a whole with some degree of discretion to determine what that means in terms of balancing the different interests of different constituencies. Shareholder enforcement is another one that's important to think about, and that tends not to be treated in these fixed conceptions of the core attributes of the company. A very important dynamic in the United States is the ability of shareholders to sue for breaches of fiduciary duty, and related to that, to bring securities fraud class actions for alleged misrepresentations in corporate disclosures. And it's important to recognize that whatever the formulation of the corporate objective is, and whoever has formal governance power, this is to some degree an effective way for shareholders to force managers to think about their interests, because if they don't, they could be sued for breach of fiduciary duty, either through a direct or a derivative suit, or perhaps if there are disclosures bound up with corporate actions, perhaps could be sued by shareholders for misrepresentations in those disclosures. So again, we can think of this in terms of a spectrum. Is the corporate litigation system strongly favoring the ability of shareholders to push boards to prioritize their interests, or is the corporate litigation system perhaps leaning in a different kind of direction, either by carving back at the shareholders' practical ability to sue, or by balancing it against the ability of other constituencies to sue? Because if other constituencies also have the ability to use this kind of mechanism, then that's going to push the board to think a little bit about their interests as well, at the same time that they're trying to balance it with shareholder interests. Share transferability is another one. Here we're talking about the ease with which shareholders can exit their investments. So this is very bound up with practical degrees of market liquidity in that particular jurisdiction, but also with corporate law rules that affect the ease or difficulty of shareholders accepting certain types of bids for their shares. So hostile takeovers would be a prominent example of the latter. So in the UK system, for example, shareholders are the last word on whether a hostile takeover goes ahead or not. The board of directors cannot implement defensive mechanisms without the shareholders having approved it. Conversely, in the United States, this is probably one of the areas where they most diverge. Boards of directors have enormous discretion to implement really powerful defenses like poison pills that have a massive inhibiting effect on hostile takeovers. And so that is something that is amenable to analysis through this lens of share transferability. Are corporate law rules making it easier or more difficult for shareholders to exit the investment in circumstances that have some big implications for lots of other constituencies in the company, as is the case with a hostile takeover, particularly if it's debt financed. Finally, there's the shareholder liability exposure question, which very closely bound up along the lines that we were noting earlier with board liability exposure. Just like with boards of directors, shareholders can have more or less insulation from practical liability exposure. And just like boards of directors, if shareholders have somewhat greater exposure, then they're going to have somewhat lesser comfort with risk. And conversely, if they have somewhat lesser exposure, they're going to have somewhat greater comfort with risk. So this, again, is amenable to conceptualization as a kind of spectrum. We have, just like with all of the others I named, we have real choices to make about where we want to land with that spectrum. So the point of all this is basically to invite creative thought. What I most react against with the fixed intrinsic conceptions of particular corporate attributes is that they have this effect of just foreclosing creative thought, because they're presented as if they were handed to us on stone tablets or as if they were derivable from some kind of economic law. But that's not true. These are all choices. And so part of what I'm really trying to accentuate is that there is a lot of policymaking prerogative that really is in our hands. We have legitimate choices that we can make about each of these individual spectrums that I've just laid out. So the idea is to sort of re-invite creative thought along those lines, both with respect to how any given lever is set. And so I'm using a kind of limited metaphor in styling them as levers. It's sort of just a straightforward way of describing a spectrum that can be set in different ways. And then also in terms of how the different calibrations of the respective levers interact with one another. Because it's not the sort of thing where you just sort of change one of these things in isolation. We have to think about what the ripple effects would be in terms of others, and whether there are different stable calibrations of the different levers that could work in different places. And I think an investigation through this lens comparatively does bear out that there are different stable forms of calibrations that look very different, but are perfectly workable within different types of political economies.
So given this framework and the creative thought that it invites, perhaps we can now then try to engage in creative thinking with regards to how we use this framework to make sense of issues of corporate sustainability. And so maybe, yes, you could maybe introduce some thought that you had about how this framework can really speak to issues of corporate sustainability, but also maybe before we dive into that, maybe you could just briefly elaborate on what you think sustainability actually entails. So there's different conceptions, maybe some people know about the 3 Ps, people, profit, and planet. There's different conceptions that one might hold as well. So I wonder, what is sort of the notion of sustainability that you work with in your work that you think speaks to these issues?
Yeah, so I tend to think of sustainability as having 3 interrelated dimensions involving environmental, social, and economic sustainability. The risk of describing it that way is it might tend to imply that we can think of each of them completely independently, that there's this domain over here of environmental sustainability concerns, that domain over there of social sustainability concerns, but in reality, they all relate to one another. So really the point is that it is a complex question. What will ultimately redound to sustainability of corporate production over time, so that future generations have the same opportunity to enjoy productive lives that we have. And this sort of 3-part structure is simply meant to highlight different dimensions of that larger question of what kind of corporate production will add up to something that actually literally can be sustained in a way that gives future generations the same opportunity for happy, productive lives that you and I have. In terms of their interactions, there are lots of ways to see how they relate to one another. With environmental sustainability, for example, not all countries around the world will be affected by climate change in the same way. Within a given country, lots of different parts of the overall polity will be affected differently by something like climate change. And so we can see how there would be disparate impacts to this sort of phenomena that would have strong social policy resonance. This is just one example of their kind of interactions. And so it's important to emphasize that complexity to the concept. In terms of ways that we could think about different types of calibrations, in the book I describe different calibrations of the corporate form that have functioned very differently over time within a given jurisdiction, including the United States, and also use this as a tool to try to understand how different types of calibrations are workable in different social and political settings in different places. So to give just a couple examples of those, historically, along the lines that I was suggesting following the financial crisis, there have been proposals over the last 10 years, 15 years, to revisit calibrations of the corporate form that might better incentivize the kinds of risk-taking practices that we would like to see. And here it's very intriguing to look to the history of the way the corporate form has been calibrated in banks. And we see this certainly in the United States, but lots of other jurisdictions as well. The fundamental move that was historically made in banks for a long period of time was to expose both shareholders and boards in different ways to greater levels of liability exposure, with the express aim of curbing their enthusiasm for risk-taking. Basically to promote strong form focus on risk and to keep the entity safe and stable. Now, here it's important to note that limited liability is not this on-off switch. It's not a circumstance where shareholders are either fully protected or fully exposed. And we see this very vividly in historical practices with things like partially paid up shares and multiple liability rules, which function very, very similarly. So if we consider a double liability regime with bank stock as just an example, the idea would be that if I paid $100 for stock in a bank and then the bank failed, I could be assessed for another $100, hence double liability. Now, it's important to distinguish that from something like completely unlimited joint and several liability. I'm not treated as a partner in a partnership. I have a much more calibrated level of exposure. And in theory, mathematically, it could be set at any level. As opposed to double liability, it could be 0.5 liability, where if I had $100 worth of stock, I could be assessed for 50. Conversely, it could be triple. The point is that you have essentially infinite variability in terms of where you set that level of exposure. It's not just an on-off switch. And this was used as a way to calibrate enthusiasm for risk in banks. Similarly, with bank directors in the United States, there are various ways in which business judgment rule protection has been relaxed, which is effectively a mechanism for increasing practical exposure to duty of care breaches in banks. And that was sort of a corollary of the kind of move that I was describing with a multiple liability regime. And when you think about the sorts of effects that this has, it's not just changing those two levers for board exposure and for shareholder exposure. For example, we would expect in such a regime to find a lower degree of governance centralization insofar as shareholders who have this kind of liability exposure are going to be strongly incentivized to monitor the board closely to make sure that the board is not taking risks that the shareholders don't want. By the same token, we would expect in such a regime to see the shareholder orientation lever adjusted downward somewhat, because in these sorts of regimes, directors were often duty-bound to focus on the interests of depositors as well, who are a category of creditors. And so to the extent that we're expressly favoring some non-shareholder constituency, we're deviating from a strong form shareholder centrism by definition. So visually, when we think of it in terms of these levers, you end up with a very different calibration of the levers that strongly militates in the direction of moderating risk. And the sorts of post-crisis proposals along these lines, which take lots of different forms, but which have this kind of fundamental logic that came up after the financial crisis, they're all with an eye toward these types of dynamics. And they are, in my view, an all too rare reflection of creative capacity to think about how the levers ought to be calibrated. Now, of course, just looking at different jurisdictions over time, if we look at something like a strong form co-determination system through this kind of lens, we see a similar recalibration of lots of different levers of corporate governance that differ from what I just described with banks, but which overall still sort of militate in a more stakeholderist direction and militate toward overall diminished risk-taking, which redounds to greater stability. Does it solve every problem? No, but it does invite this kind of creative thought about how the levers of governance have been calibrated over time and how they could be calibrated moving forward to respond to some of the downsides of corporate production, which sort of brings me back to where we started, which is not to suggest that the whole thing is fundamentally broken. It's just to suggest that we could exercise more creativity and real concerted thought about how to rebalance things to retain a lot of the benefits while reducing some of these costs.
And so when we stick with the question of reform, I suppose, just to bring in perhaps a different perspective that says, let's not mess around too much with the corporate structures themselves. Let's look at extra corporate regulation outside of the domain of corporate law, so in environmental or labor law. And similarly, let's not mess again with the corporate structures, but maybe just introduce a certain kind of disclosure requirements, reporting maybe has to be more sophisticated, has to become more integrated. How do those kind of proposals fit in with maybe the reform sort of lens that you introduced, which is much more concerned with actually being much more nuanced and creative about these different levers and how that actually affects the corporate structures as they operate in the world? How do those different proposals kind of, or reform lenses, relate to one another?
Yeah, so I think I'll take them in reverse order, starting with disclosure and then turning to what we're styling here as extra corporate regulation, meaning simply substantive regulation through other bodies of law, say like environmental law or labor law or whatever it might be. With disclosure, I tend to think of disclosure as an essential predicate to meaningful reform. But the problem is that as a matter of political reality, it often substitutes for real reform. So if you imagine a sort of jockeying or competing lobbying between one group in society that wants to see more regulation and another that wants to avoid regulation, in a way, disclosure sometimes functions as a kind of perfect solution that allows everyone to declare victory because the reformers got their reform. They can say, see, here's the new rule that they're subject to. Meanwhile, the regulated entities can declare victory because they can say, well, look at the rule, it doesn't make us do anything. Mm-hmm. And you have a sort of you have a sort of new equilibrium where the disclosures will include often vacuous boilerplate disclosures that sort of nominally toe the line of the regulation, but which don't translate into the kind of investor or consumer pressure that would be required based on those disclosures to actually prompt a different kind of corporate behavior. And so I'm obviously painting with a broad brush here. We could point to some examples where pure disclosure works, but I think we can point to many, many examples that sort of follow the path that I just described. And so the actual political economy reality in terms of the formulation of these rules, I think is important. And as a practical matter, I think too often disclosure ends up substituting for real reform in a way that doesn't require anybody to do anything, allows everyone to declare victory, and then nothing actually happens. So that's kind of, from a 30,000 foot view, my sense of the disclosure side of that question. With respect to extra corporate regulation, I would never suggest that other bodies of law aren't important. I mean, obviously, it's critical that we have meaningful, robust environmental regulation and meaningful, robust labor and employment regulation, among many others. The problem here, I think, is that the formulation of new rules in those areas will, to some degree, be reflective of anti-regulatory force that comes from corporate entities themselves. So a very vivid example of this in the United States involves the ability of corporations to make substantial contributions to electoral campaigns for officials in federal and state governments. The degree to which corporate entities can impact directly or indirectly the content of the regulation that's supposed to constrain them calls into question whether those forms of regulation can really function effectively to completely correct the sorts of problems that we're talking about. If you hold bad incentives constant, and then count entirely on these external forms of regulation through, to some degree, manipulable political processes to be the mechanism that's going to completely constrain corporate conduct, I don't think it's going to work. And of course, it's not just things like campaign contributions. There are lots of other avenues through which corporations can exert very substantial pressure on regulatory structures. Another element of this in the United States is substantial ability to challenge administrative rules in court. We are effectively at a point where new regulations that would have a substantial constraining effect on corporations are only sort of half done when they're issued by the regulator. The other half of the process will be testing them in court. And there are a lot of different theories that corporations can use to attack those sorts of regulations, some of which are substantive and some of which are procedural. So from my own perspective, the question isn't, do we want external regulation? Undoubtedly, we do. The real question is whether we can rely on it in isolation to solve these sorts of problems. And I think what we've seen is that unless you really recalibrate the core incentive structures of these entities, really recalibrate what it is they are built to want to do, it would be very, very difficult, if not impossible, to get to a real solution.
I have one question that comes to mind, and so in some sense, you advocate for an industry by industry approach, I suppose. And I just wonder, but this perhaps goes against the sort of comparative lens. But anyway, let me try anyway. If I would sort of suggest, can you sketch the ideal business corporation? What is its constitution? What is its configuration? I'm wondering whether you think it makes sense to talk about a certain ideal. So let's say the nexus of contract view of let's say firms and the sort of corporate law lens that sort of is attached to it. There's a certain ideal that is being sketched, which may actually not be always empirically realized. And I wonder if here the reverse is true, whether there is a lot of nuance and it's exactly how it should be in terms of let's look at the actual industries. Let's look at all the complex sort of ecosystem dynamics that we have to take into account. But I wonder if this question of the ideal, let's say if someone operating within sort of the business context is supposed to relate to this sort of constitutive role of corporate law and how it sees itself maybe in their economic operations being embedded in that legal reality. What's that ideal there that is sort of interacting with maybe perhaps their sort of managerial ideals in terms of how the organization should be run? So it's to some extent also a question about the division of theoretical labor, about how we perhaps understand the corporation. But given that there has been this sort of interaction and maybe even sort of imperialism of, let's say, the economic lens to take over, I wonder whether you think that this kind of legal lens, right, which is very nuanced and which actually already recognizes that it has to interact with these different contextual drivers, which are indeed economic, historic, etc. What's the role of the ideal here of the business corporation as a particular kind of entity that goes into the realm of sustainability? I mean, maybe it's a mischaracterized question, but I still want to ask it.
Yeah, it's a fair question. The basic structure of my model, of my approach to thinking about the corporation sort of militates away from positing some particular ideal along these lines. Now, to the extent that that's the case, the fair follow-up question would be then, okay, well, if that's true, then how do we actually implement any of this? There are different ways you could go about it. One way would be to change the fundamental corporate law that would apply to all types of entities. And I'm very alive to the concern that raises about excessively curbing risk and maybe jettisoning too much of the benefit for what could be minimal reduction of the cost. So in other words, I'm alive to that kind of concern. In the book, I suggest that we could take an industry by industry approach or think about paradigmatic situations where we might want to depart from the present status quo in favor of a different kind of calibration. So there are different ways that this could be approached. I've sort of broken it down into three categories. I've thought first about financial firms, where there's a very strong argument that we should want a different calibration, particularly in terms of risk-taking incentives, and actually have a lot of historical precedent to look to in terms of alternative types of structures that, at least even if we weren't just going to resurrect those structures, that would prompt creative thought about different types of things we could do today. And with some nuanced approaches to structure could yield real benefits. So financial firms would be one such category. Another category that I address in the book would be what I'm terming essential non-financial firms. And so basically the question becomes, okay, what are other circumstances that kind of resemble finance in terms of moral hazard concerns and systemic consequences of failure that really raise the cost of risk-taking to society, and that might lead us to want a different kind of balance. And so the sorts of things I'm thinking about here would be a category of firms that we kind of alluded to earlier, that are sort of in that blurry category between public and private, in the sense that they have a very strong kind of infrastructural role, perhaps. So firms that are essential to mass transportation within the country, something like an airline or an airplane manufacturer, that sort of thing. Those sorts of firms that we treat as private actors, but which have a very strong public valence because of their economic and social significance, as well as their environmental impact, potentially. Those sorts of firms could have moral hazard dynamics and systemic significance in terms of what the consequences of a failure would be, that really strongly resemble what we normally associate with banks. And so that would be a significant candidate for kind of rethinking what governance ought to look like in that sort of setting. Another category that I've considered would be companies with inherently hazardous business models. So here we'd be talking about the sorts of firms that would already be on the radar screen of like federal environmental law in the United States, in terms of having the potential for a really bad accident that could create massive cleanup costs, this sort of thing. The sort of firm that would be subject to the federal law CERCLA in the United States and analogous laws in other countries. That's another one where we have kind of more systematic reason to be concerned about potential costs that vastly exceed the assets on the balance sheet. And that would be another category of firms where I think it would make good sense and potentially yield real benefits to rethink what governance looks like. And so to sort of return to your question, is there some alternative ideal that I would flip to? No, it's not a matter of substituting a different kind of ideal conception for the ones that currently prevail. It's more an insistence on this kind of nuance, but with some systematic dimensions to it. I wouldn't, in the first instance, advocate necessarily altering all of fundamental corporate law that applies to all firms in all circumstances, but taking that as the baseline. I think there are these categories of firms that really ought to be scrutinized through this kind of lens, and where we could get a lot of the benefits that we're looking for in the aggregate without having to flip everything on its head for all categories of firms.
Right. No, I think that's very helpful. Maybe finally we could talk about corporate accountability. And so here you discuss, I guess, two main issues. One is the nature and scope of the directors' duties and their accountability and the composition of the board. And then secondly, the issue of global value change and how legal responsibility should be distributed in those kind of scenarios, and how or whether legal responsibility actually sort of bubbles up to, let's say, the parent companies or not. So perhaps you can lay out this sort of reimagining of corporate accountability from your account that speaks directly to issues of legal responsibility.
Yeah. So in terms of the composition of the board, I mean, this is one of those. This is perhaps another enduring question that is very difficult to answer in a really comprehensive way. Like, what would be the composition of the ideal board of directors? That is an exceedingly difficult question to answer. But we see in some of the contrasts that we've already talked about that there are very different ways of thinking about the composition of the board of directors. Again, the most dramatic being the comparison between a purely shareholder elected board and a board where, say, labor gets to elect part of the board. Even short of that, though, doing thought experiments of this sort might lead to interesting intermediate sorts of structures. And so, for example, in the U.S. context, maybe we decide reasonably that as a political matter, it would be impossible to adopt something like continental codetermination in kind of the full-blown way, but that there are intermediate structures we might use, like board committees or advisory committees and so forth, to at least make labor interests more prominent in the deliberations of boards of directors. And so there's that sort of intermediate structure that might arise from this kind of comparative exercise and flexibility in terms of thinking about the composition of the board. Even if it doesn't alter the board composition in the United States, it might lead to creative thinking along those lines. We of course resort to reforms in the United States that do affect the composition of the board all the time. The most prominent form this has taken in the United States has been different types of rules that are meant to promote independent directors on the board. So in other words, rather than having a board that is completely dominated by insiders to the company, people who are executive officers of the company, trying to promote independence along those lines, have others who bring in other types of perspectives from outside the firm, as it were. We don't normally formulate it in that way in U.S. discourse, but this push that we've seen toward having more and more independence on the board is effectively a way of kind of rethinking what the composition of the board should be. And there have been lots of other proposals along these sorts of lines, at least at that mid-level of abstraction, over recent years that are sort of continuing to grapple with this question of what ideal board composition looks like. I think, although it's impossible to say with specificity, here is the ideal composition of a board of directors in any particular place, let alone globally, there are things that we should bear in mind when we're thinking through how to approach this. There is some evidence that diversifying the board of directors along different types of axes could offer benefits in avoiding groupthink, by which I mean that form of false consensus seeking that you get when there's too much commonality among the people on the board of directors. In a very generic way, that I think there is reason to believe that diversifying the board of directors in different types of ways could deliver benefits in that form of avoiding false consensus seeking and bringing more inputs to bear upon board deliberations. Those are the types of considerations that I'm considering in that part of the book. And then with respect to global value chains, this is something that's getting a lot of attention on both sides of the Atlantic right now, because of course in Europe you've got the corporate sustainability due diligence directive that was adopted last year, which I gather now is sort of bound up in the omnibus process to think about how it relates to the corporate sustainability reporting directive and perhaps others. In any event, this is basically responding to increasing recognition that the increasing complexity of value chains in modern production further and further distance investors and consumers in multinational parent companies and lead firms in contractual arrangements from the consequences on the ground of what happens to produce the products that they are enjoying as consumers and benefiting from as investors. And so basically the idea with these sorts of laws is to impose some degree of obligation on the parent company in a multinational group or on the lead firm in a contractually organized value chain to monitor for different categories of environmental and social abuses and to take actions to try to reduce those problems and potentially to have real accountability if they fail to do that. So obviously this has become controversial in Europe recently in light of the costs of implementing this. It's not an easy thing to do. We do not have such a comprehensive law in the United States, although it's worth noting that we do have certain structures under trade law that work in a similar kind of way. So for example, Section 307 under the Tariff Act of 1930 basically makes it illegal to import into the United States products produced with forced labor. And this sort of law incentivizes due diligence for importers. And there have been different forms of application of that provision that more strongly incentivize due diligence in particular contexts. And so that is a kind of limited due diligence law in the U.S., but it's styled as a matter of trade law rather than. As I described in the book, I am in favor of more robust application of these kinds of structures. And in some of my more recent work since this book, I've been sort of exploring the interface of corporate law and trade law in this respect. both as it affects the politics of how we think about this type of structure, and what the advantages and disadvantages are of pursuing different forms of regulatory packaging for this, whether it be corporate law on the one hand or trade law on the other. But that's essentially what that is about.
I wonder, maybe on this last point, and I might be off here, but I wonder whether this also speaks to the issue of like corporate groups, because I suppose like a lot of corporate law takes corporate personality to be one of, let's say, the core features or core attributes of the corporation. But I do remember reading a book, I think by Bloomberg, if I pronounce it correctly, like a corporate law theorist actually in the 20th century at Connecticut, who wrote also that corporate law has to be completely rethought now that we have corporate groups. So we have to basically trace or track, much more complex configurations of a bunch of different corporate personalities that sort of are the, let's say, structure of some firm that integrates all those different corporate personalities. And I'm not sure if this is maybe going slightly off to a different kind of direction, but I still wonder how that fits in with a lot of the things that we have discussed, because there are some people also debating what the relationship is, for example, between, let's say, the firm as a concept and, let's say, the corporate person as a concept. And one issue is that some of the definitions that we might give of these two different concepts don't really align, as soon as you take into account that most firms or larger multinational firms actually have very complex configurations of a corporate personality that might not fit even just the pursuit of, let's say, issues like economic efficiency, but might actually be more financially beneficial in terms of how to use these legal instruments to certain advantages having to do with, let's say, tax or other issues. And here specifically the book that comes to mind is from Pistor, The Code of Capital, which is really sort of, I guess, taking a complementary lens of a lot of the things that you discussed, but nevertheless also looks at this legal technology. I guess he also uses the word technology, actually. So I wonder, like, I mean, maybe this is a different kind of topic, but I still want to bring it in terms of now we have this dashboard and these different levers. Does that also speak to the issue of the corporate groups and how we think about that alignment between, let's say, the firm and more of its legal manifestation?
Yeah, I think that's absolutely right. The what we're seeing and grappling with here in terms of global value chains is very much bound up with the forces that you're describing. I mean, what this is all really pointing to is the ability to divvy up liabilities and assets related to an overall business in lots of different ways, and particularly to hive off assets from liabilities in different sorts of creative ways. And so you first see this with formal corporate groups, right? That's sort of separating different pockets of assets and liabilities in different subsidiaries, and then taking the position that they are sort of hermetically sealed from one another by virtue of each having its own corporate veil. That would be the first step. And then, of course, the second step in terms of insulating the ultimate consumer-facing business from liabilities that might be associated with the modes of production would be the contractually organized value chain, where the idea is it's not even really formally a corporate group, and so even the limited forms of liability should be imposable across a corporate group should not apply here, because these are nominally all arm's length contractual relationships. You can think of those as different points on a continuum moving toward greater and greater sort of legal fragmentation. Basically, I think in many respects, in an effort simply to insulate affluent consumer-facing companies from liabilities associated with their modes of production. What we're seeing with these global value chain type rules is effectively a reaction to that, a kind of pushing back at that kind of strategic carving up of the overall process of production to bring assets and liabilities into closer relation once again. It's all very dynamic, and we're at a point where it's difficult to say exactly what's going to happen with it, including in Europe, where the most advanced steps of this sort have been taken in the form of the Corporate Sustainability Due Diligence Directive, the fate of which I gather is now somewhat uncertain. But basically, that's what these sort of steps are aimed at countering if we view it through the lens of kind of corporate group dynamics. So I agree that's very much bound up with those sorts of factors.
So perhaps as a final question, to what extent do you think that sort of, let's say, the key concepts of sustainability can be sort of embedded into corporate law full stop? So I think there are some proposals out there. I think one of your colleagues, Professor Chafiel, She has an article that I've read a while back, which kind of says, well, we can actually employ these concepts, sustainable value creation, planetary boundaries, and create this sort of complex web of concepts and put them right at the heart of corporate law, and also relate them to the duties of the board. That doesn't sound quite like the reforms that you propose, but I wonder how you think about that proposal, I suppose. So because that sounds to me also to some extent more like sort of the purpose proposal by Mayer, like we have to just go straight to corporate law, get certain concepts deep down in there, sort of as the fundamental sort of conceptual, let's say, elements, and work from there. And I'm just curious, like, how you position yourself in relation to such a proposal.
Well, I think that is a very important set of considerations, and that there are strong arguments to be made for it. What this translates into in any particular country, to sort of circle back to the contextual features that we were talking about early on, could militate in a lot of different directions. I think the bottom line is that the basic features of the political economy can vary so much from one country to another that the practical opportunities for these sorts of reforms won't necessarily look the same from one country to another. And by the same token, the degree of social buy-in, you could say, for the sustainability concept is also going to vary from one country to another. Maybe even the vocabulary that people will use to describe these kinds of ideas. And so I think that as plausible as this might be in a particular social context, it's one can't assume that it's going to be, that it could translate into the same sort of structure in all jurisdictions. And we have to be very sensitive to the political realities in a particular country. Part of what I'm hoping to promote with this kind of more flexible conception of the corporation is thinking about potentially lots of different ways in which these sorts of things could be implemented from one country to another, depending, among many other things, on these kinds of political realities and differing levels of social buy-in to the sustainability concept. And so I suppose that would be my response. I'm very sympathetic to those proposals and very supportive of that kind of strong form sustainability orientation, while at the same time wanting to think practically about what the kinds of opportunities might be in any given country, and recognizing that they won't be the same.
Now, let us end with that contextualist note and call for experimentation. So, well, it's been fantastic to speak with you. For people maybe interested in learning more about these topics, I will link all the books that we mentioned during this conversation in the description, including several of the books that you wrote and also co-edited. Let me also briefly say a big thank you to the Rudolf Agricola School for Sustainable Development for providing me with the grant to produce this podcast series. And Professor Bruner, thanks again for coming on the podcast. It's been a pleasure.
Well, thanks so much. It's been my pleasure.